All rise. Oyez, oyez, oyez. The Honorable Court of Criminal Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
A word of welcome to everyone to the April term of the Court of Criminal Appeals for East Tennessee. And on the panel today, I'm pleased and privileged to have to my right Judge Tim Easter from Williamson County, and to my left Judge Tom Greenholtz from Hamilton County. My name is Kerwood Witt. I'm from Monroe County. Arguments are 20 minutes aside, with the exception of a slight deviation for the first case. And if you are representing the appellant in your argument, and you want to reserve a portion of that 20 minutes for rebuttal, I request that you make that reservation at the beginning of your argument. I don't believe we have any preliminary matters.
No, Your Honor.
And so would you call the first case for us, please, ma'am?
Kris Theotis Young versus State of Tennessee.
Good morning, Your Honors. Drew Justice for the appellant, Kris Young, and I'll reserve 4 minutes.
4?
Yes, Your Honor. A kidnapping requires, by definition, a duration of confinement and/or distance of aspiration that have to be substantial. So the most glaring problem with the conviction in this case is that the jury was never told to even look at the time or distance, or to look at whether they were substantial. That issue was never raised by appellate counsel. Appellate counsel never demanded, in essence, that the jury be instructed on the very definition of the crime itself. Not only did appellate counsel not raise this issue, but he never raised any challenges whatsoever to the conviction, or even filed any motion for new trial, motion for acquittal, anything along those lines. When you have a kidnapping that lasts for several minutes, to use this court's own words, that's not where the distance being carried is not any meaningful amount. That's not what people normally classically think of as a kidnapping. And in fact, it's strongly suggested, if not outright held in State versus White, that cannot be a kidnapping, and that as a matter of law, the evidence is insufficient to sustain a kidnapping conviction. Again, White specifically held, which was different from prior law, that the duration and/or distance or combination needs to be substantial.
Counsel, are you raising this as a standalone issue, or are you raising it solely in the context of ineffective assistance of counsel? I mean, you would agree with me that this would not be a standalone issue that you could maintain, wouldn't you?
The way I styled it in my brief, I was sort of trying to leave open both options. However, the main avenue is ineffective assistance.
Well, just in terms of argument here, your first option's foreclosed. Is that correct?
Probably.
Okay, so we're really then just talking about ineffective assistance of counsel?
I believe so. Because
what was the testimony then at the post-conviction hearing from trial counsel about why these issues weren't raised or discussed?
Trial counsel did not give any strategic reason for not raising this issue. His only reason that he did give was that he thought that the issue was somehow precluded. The problem with his explanation is that it's just objectively wrong. That's not how law of the case works. The law of the case is not the Tennessee Supreme Court's held that law of the case is not a constitutional mandate nor a limitation on the power of the court. Rather, it's a long-standing discretionary rule of judicial practice. And so when you have a court that's previously, where your opponent has previously won an appeal based on the fact that jury instruction A wasn't needed, and then you're remanded down, and then you're the loser, and you get to appeal, and you get to go on the offensive, as it were, you're not just barred from raising a deficiency of jury instruction B at that point. And for some reason, trial counsel or appellate counsel thought that he was, and that was his only reason for not raising this issue. I will say that the way we've styled the brief, part of it's due to the fact that the post-conviction judge really didn't base any of his rulings at all on whether or not the previous counsels were deficient. He just ruled that, on the merits, you're not entitled to this jury instruction, you're not entitled to a vagueness challenge, etc. And so the way we've styled the brief, if somehow appellate counsel were foreclosed from raising the issue previously, then that would only solidify Young's ability to raise the issue as sort of a standalone claim in post-conviction.
How would that be possible?
Well, the rule is you either...
If he wouldn't be able to bring the claim because the law of the case doctrine precluded it.
I mean, the rule is that you can bring any constitutional claim unless it's been waived. The main way that petitioners get around waiver is by saying my counsel was ineffective, and that's the main argument we're raising here.
Except that it's not. The standards are different. So if you're judging it purely from the decision on the merits, such as the sufficiency of the evidence standard, that's measured differently on the merits as opposed through the lens of the Sixth Amendment. The standards are different, so it's not trying to get around the waiver. It's a substantively different standard.
I think once you get to the issue of judging the merits, I'm not sure the standard is that different, but one way, I'm just saying whether the standards are different or not, either appellate counsel could have raised it and should have, or if for some reason he could not have, then we're allowed to raise it now separately. But again, the state hasn't really pressed any argument that he was barred from raising it, and I don't think he was barred. I think under Rule of Criminal Procedure 30, as well as State versus Cecil, other case law saying that you're allowed to include omissions of key jury instructions in your motion for new trial, even if you didn't specifically ask for them before. All that, plus the fact that White is just a new instruction where they've changed the law. State versus Cecil specifically says that the White ruling applies to cases in the appellate pipeline. So I don't think that there was any bar on trial counsel raising the issue. Again, it wasn't barred by law of the case. The Supreme Court never addressed, none of the parties addressed at all this issue of whether Young should have been entitled to a substantial duration instruction. And the fact is, it's entirely possible to be unentitled to a White instruction, which is about essentially incidental crimes, but still be entitled to a substantial duration instruction. And in fact,
unless the other members of the court have a thought here, could I move down to your fifth issue, which is the plea offer in session court?
Yes, Your Honor.
Did the post-conviction court find that there was no plea offer conveyed?
His ruling is not super clear, but I believe, yes, he did find that.
Okay. How can we rule for you then?
Well, the standard of review for factual issues on post-conviction is supposed to be de novo with a presumption of correctness. So there is some deference involved, which is the presumption of correctness, but we believe we can overturn that based off the fact that
it would be entitled to the presumption of correctness if there is evidence in the record that supports the finding, correct?
Yes, Your
And
Honor.
there is evidence in the record that would support this finding, right, if he credited the testimony of the prosecutor?
Well, my understanding is that the presumption of correctness can be, it's a presumption but it can be overcome if I can show that the evidence preponderates against the lower court's finding. Here we had the lower court's finding, assuming he made one, which is not totally clear, but assuming the lower court made the finding, it was based on the testimony of the prosecutor, who admitted that he didn't specifically and personally know what he was testifying about, but that he was testifying from the file, as he put it. He admitted that he had previously made statements saying he didn't know whether a plea offer was made. And so, in essence, the prosecutor was just doing what the post-conviction court was called on to do, which was to sort of draw a legal conclusion based on, looking at the file. And so, anyway, if all you've got is one witness on the prosecution side who doesn't specifically know what he's talking about something 11 years earlier, and he admits that he's just testifying from the file. And then on the other side, you've got at least one defense lawyer who specifically says the offer was made. I remember it being made. Then you've also got this other defense lawyer who we've got this dispute about whether that's even in the record. But assuming it is in the record, this other defense lawyer is also corroborating that the offer was made based on his secondhand knowledge around that same time.
So is it a credibility determination?
Well, what I'm getting at, I guess, is that it's not so much a credibility determination, because the prosecutor might sincerely think he didn't make an offer, but if he admits he doesn't really know and he's sort of guessing, then I just submit that his testimony is not entitled to any great deference or weight.
And if you or I were a trial court judge, that may be different, but on appeal, aren't we bound to give the credibility findings made by the trial court weight?
I don't believe, well, you're entitled to again, give it some weight, but again, in Fields versus State, they talk about the difference between a pure credibility determination. In other words, is this witness lying versus just an ordinary fact finding? And I would submit that this post-conviction court's fact finding fell into that latter category. He wasn't really saying, this witness, I can tell he's telling the truth, and he says that there was no witness made. It was more like, well, this witness, doesn't remember one being made. The fact is, he could not remember it being made, but it still was made. If it happened 11 years and hundreds or possibly thousands of cases earlier, and he's just testifying based off the fact that, well, I didn't write it down, so therefore it didn't happen. Well, if two other witnesses say it happened and you just don't remember, all those things can be true. It can really have happened and you just don't remember it. And we've also got the testimony in the evidence of the fact that my own client's trial counsel has been effectively disbarred or long-term suspended due to not communicating with clients. I mean, just all the circumstances do corroborate that an offer was made, regardless of whether the prosecutor remembers it.
What evidence is there in the record that the trial court would have accepted the offer if it in fact was made?
I don't think there's any specific evidence of that in the record. However, I don't believe that that's a required standard under that type of post-conviction claim. I think it's called a Lafler claim. I'd have to look into that. I didn't specifically.
You don't think that's part of the standard? That the trial court would have accepted the plea?
I've never been, that's the state never made that argument below. They never made that argument in this court, and that issue has not come up to me, so I don't specifically know.
If it is part of the standard, is there proof in the record by which this court can make a conclusion that that prong had been satisfied?
We did not put on any specific proof about whether the judge would have accepted the plea. We'd have to call the judge as a witness, and I don't.
Well, it was a plea that required a plea of all three individuals, is that right?
Yes, but there's testimony in the record from all three individuals that they all would have taken the plea.
There is testimony in the record to that effect?
Yes, there's testimony from Jarrell Alston via, his own hearing, which was introduced by transcript, and then there's testimony from Joshua Webb, one of the co-defendants, and testimony by Kris Young that they all would have accepted the plea if they had been notified about it.
Okay.
But as far as the judge accepting it, though, no, we did not address that. And then, how much time do I have left?
You have 7 minutes left.
All right. I did want to briefly cover this. Issue about the crime of kidnapping in Tennessee being void for vagueness. Federal law is clear that when you have this basically just unspecified crime that has to be decided on an ad hoc basis, ad hoc resolution by policemen and juries, that is unconstitutionally vague to have that kind of crime, and it violates the 14th Amendment. Here we have, in Tennessee, we've got this kidnapping charge that's so vague where the jury can just basically say, well, kidnapping can be whatever I want. And so if the jury feels like it's a kidnapping, well, they go with it. That's just an ad hoc decision. And I would submit that in Tennessee, we don't seem to have any meaningful appellate review of this type of kidnapping. I do understand that there's a different type of kidnapping where you do involve an essentially incidental crime, and I have seen cases where those types of convictions have been reversed. Those are at least somewhat meaningfully reviewed on appeal, but for this type of conviction of a so-called pure kidnapping, I've never seen one where the appellate court has ever said, based on sufficiency of the evidence or any other ground, that it just can't stand. And so,
again, is this a claim that has been waived?
The void for vagueness, well, what we're arguing is that, again, it should have been raised by trial counsel. And we had testimony from appellate counsel that, yes, it should have been raised by trial counsel. And so I don't think appellate counsel probably could have even raised it because he got appointed after the conviction. When you file a motion to dismiss an indictment, that's normally, not always, but normally got to be done before conviction. I would submit one or the other should have raised that.
If it's a Sixth Amendment issue and the fault is being laid against trial counsel for failing to raise the void for vagueness in the trial court, what did the trial counsel testify to at the post-conviction hearing?
Trial counsel did not testify, but our position on that is that we don't need trial counsel to testify because there's just no objective reason for not raising this issue. You can look, there's no possible strategic grounds that the state or anyone can fathom for why it would have been a good idea not to raise this issue. In addition to that, appellate counsel did specifically testify that it should have been raised.
Why did appellate counsel not raise it for plain error?
Again, I'm not sure that appellate counsel could have raised it because for a motion to dismiss an indictment, normally you have to raise that pre-trial. There could be possibly an exception.
You were down to your reserve time if you want to preserve that.
Well, in terms of this issue, just to very briefly recap on the constitutional points, the federal courts have held that if you have an abstract measurement, like an unclear, just vague measurement of an abstract philosophical or legal concept as opposed to something concrete, those two things put together ordinarily or can very easily make for an unconstitutionally vague law. And so when you have that principle and when you have the fact that Tennessee courts have never, as far as I can see, overturned a pure kidnapping conviction, and when you've got even the state making the argument that 45 seconds of duration and no distance at all, that's enough for a kidnapping, I just submit that all that together makes for a terribly vague law, and previous counsel should have challenged it. I'll come back for rebuttal.
Thank you.
Good morning, Your Honors. May it please the Court, Nick Spangler for the state of Tennessee, and specifically here on behalf of General Orr, who prepared the state's brief in this matter. Your Honors, because the post-conviction court correctly denied all the petitioner's claims, its order should be affirmed. So to the extent the petitioners raised several standalone claims here challenging the jury instructions on kidnapping, sufficiency of the evidence, a vagueness challenge to the kidnapping statute, and a double jeopardy challenge to his robbery and burglary convictions, those claims are either waived or previously determined because they either weren't weren't raised on direct appeal but could have been, or they were raised and decided against him, in which case they're previously determined. So opposing counsel seems to make this argument, maybe abandoning it now here today, that basically the ineffective assistance of counsel somehow excuses these procedural bars, but that's simply not the case. And that gets to a point that Judge Greenholtz made, which is the standards for each of those claims is different. So an ineffective assistance Sixth Amendment claim doesn't just turn on the merits of an underlying standalone claim. You also have to prove that counsel was deficient in the handling of that issue, and also that there's a reasonable probability that the outcome of the proceedings would have been different had counsel handled that issue competently. So the first ineffective assistance claim the petitioner raises kind of clearly illustrates the difference between these two inquiries, I think. So he claims that that there should have been this special instruction for kidnapping to basically qualify the elements of confinement and removal to establish that those needed to be substantial or significant. And he claims that counsel was ineffective for not pursuing that novel jury instruction. But let's just assume he's correct, and let's say that this court were inclined to go forward and issue a decision that says, yes, he's entitled to this special jury instruction. That doesn't establish that counsel was deficient for failing to pursue that instruction. And the reason for that is the law says that counsel can't be deemed inefficient or ineffective for failing to anticipate changes in the law or arguing novel legal theories. And I think the way this point is articulated best is actually if you look at the White decision. White came out and held that there's a requirement for this special jury instruction to make sure that kidnappings aren't essentially incidental to an accompanying felony. So after White came out, there were post-conviction petitioners who came along and said, hey, my counsel didn't argue for the White instruction. I didn't get the White instruction. My counsel was deficient. They were ineffective. There are specifically cases on that point. I think Pearson versus State is one of those cases. And those cases made it up to this court on appeal, and this court said, no, just because, White's counsel got that jury instruction, your counsel wasn't ineffective or deficient for failing to anticipate that instruction. They were not ineffective. You're not entitled to post-conviction relief based on that ineffective assistance claim.
Didn't the Supreme Court, in this case, in Mr. Young's case, weigh the facts of Young against White and said harmless error?
That's correct. That's correct, Your Honor.
So maybe this is a better question from Mr. Justice. How can the petitioner then expect us to find by clear and convincing evidence in a post-conviction posture that there was some violation here?
Exactly.
Of any right.
Yeah, and I think this gets to the heart of an issue. I think, we kind of went back and forth in our brief between calling some of these claims, these standalone claims, previously determined or waived. And I actually think the best characterization of all the claims is that they're waived, because I think petitioner on this appeal does make slightly different arguments than the standalone claims that he raised in that initial direct appeal. In other words, he raised the White issue on the original direct appeal. And I think this claim is a little bit different insofar as he's saying, you should have qualified this confinement or removal element, basically defined kidnapping differently. But I think it's interesting, if you actually look, he cites the Tennessee pattern instruction for this, the instruction that was given, and that instruction says removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. So the pattern instruction already requires this element that the confinement has to be significant. I think his only proposed change is that word significant should be changed to substantial. I propose that's an insignificant difference, and certainly counsel wasn't deficient for failing to request that special instruction and that change in the definition or the qualification of the term confinement. Another point that I want to make here is repeatedly throughout this claim and the 2 or 3 other ineffective assistance claims that petitioner raises, he alleges that appellate counsel, after the limited remand for sentencing, was ineffective for failing to file a motion for new trial and raise these issues challenging the underlying convictions on the second round of direct appeals. And that's completely inappropriate, because the Supreme Court issued a limited remand for the purpose of sentencing on those counts that never received sentences, because the trial court dismissed 2 or 3 of those counts. And so the Supreme Court's remand was on the limited issue of sentencing. So it was completely appropriate that on the second round of direct appeal, appellate counsel only challenged issues related to sentencing. The law is well established that appellate courts can issue limited remands, and then the issues at stake, both at trial and on any appeal stemming from that remand, should be limited to those issues in the limited remand. It would have been, he already had a round of direct appeal to challenge the underlying convictions. It would have been inappropriate for him to file a motion for a new trial or raise claims on direct appeal challenging those underlying convictions. So that's a point that I wanted to make about this claim, as well as the sufficiency claim, as well as the void for vagueness challenge.
General, is there, and excuse me for interrupting.
Sure, no problem.
Would you address the petitioner's double jeopardy argument for me, please?
Sure. So petitioner's fourth, the double jeopardy argument you said?
Yes, sir.
So the petitioner's fourth ineffective assistance claim says that his convictions for kidnapping and robbery don't violate double jeopardy principles. And this claim is premised on the idea that the state somehow improperly divided the robbery up into two separate robberies. So, but remember, petitioner was only convicted of a single robbery, not two. So to the extent he's pressing kind of a unit of prosecution double jeopardy argument, that claim clearly fails because, again, he was only convicted of, punished for one single robbery. And to the extent he's complaining about dual convictions for kidnapping and robbery, that's essentially a multiple description claim, and that claim also fails. And the reason for that is, in Watkins back in 2012, the Supreme Court established the test or the analysis for multiple description claims, and the last step of that analysis asks whether the two conviction offenses are essentially the same offense or whether one is a lesser included of the other. And the way you answer that question is you look to Blockberger and ask, does one offense include an element that the other does not? And if you look here at robbery and kidnapping, robbery clearly includes a theft element that kidnapping does not, and kidnapping clearly includes a false imprisonment element that robbery does not. So to the extent he's raising kind of a multiple description double jeopardy claim, that fails as well. And certainly on the IAC issue, the ineffective assistance issue, counsel was not ineffective for failing to raise either a unit of prosecution or multiple description double jeopardy challenge.
Thank you, Joe.
I'll move to the next issue that petitioner covered in his argument, and that's the claim that Judge Greenholz, you asked about, and that's this claim concerning counsel's alleged failure to convey plea offers. So as you pointed out, Judge Greenholz, the post-conviction court's finding with an underlying credibility determination that no offer was made in General Sessions Court is essentially conclusive on appeal. The petitioner essentially invites this court to reweigh that evidence, to contrast General Allen's testimony with the testimony of two defense attorneys about this offer, but the law is well established that factual findings with underlying credibility determinations like this are to be given the weight of a jury verdict, and that an appellate court cannot reweigh or reevaluate that evidence. So
the petitioner, I gathered from argument, was asserting that the post-conviction court actually made no credibility finding. Is it possible that the post-conviction court could have reached the ruling that it did without making a credibility finding?
I think it's not. I think it is accurate. I looked at the order very specifically to see if that express credibility determination was made, and it is not. It is not in the post-conviction court's order. But I think your point is correct, that basically it couldn't have found that the plea offer was not made without essentially or implicitly accrediting General Allen's testimony that no plea offer was made.
As I understand from the petitioner, there were two trial counsels representing the co-defendants that either testified affirmatively that there had been a plea offer, or at least maybe perhaps in a worst case scenario didn't dispute it. And so there was at that point a true credibility determination that had to be made if a resolution was going to be obtained. Is that correct?
I think that's correct. And I think the only reasonable read of the post-conviction court's order finding that no offer was made was an implicit credibility determination made that the court believed General Allen that no plea offer was made. And that does get on a point that I wanted to touch on very briefly too. I don't know if the court's going to allow more time for this judicial notice issue, but the question of whether there were two counsel that testified or would have testified about this plea offer being made. So I think one was Mr. Brown, who was Mr. Webb's counsel. I think he did testify at the post-conviction hearing that this offer was made. So the other one in contest here is Mr. Gindy's testimony, or would-be testimony. This is the subject of the motion to take judicial notice. Apparently, there's also this testimony, or this transcript of testimony, where he also testified at least knowing about this plea offer. But one thing I'd like to point out there is I haven't seen the testimony, but from what I gather, it would essentially be hearsay testimony from Mr. Gindy, because I think he had no firsthand knowledge of this alleged offer. He's only testifying about something that he learned about after the fact. And on the judicial notice issue, I would submit that this is just a record problem, that this is petitioner bears the burden of providing an adequate and complete appellate record. And to the extent there's some confusion about whether this exhibit was or wasn't introduced, I take Mr. Justice at his word that if he introduced this or tried to introduce this, that he did. But nonetheless, as it stands, that transcript is not available to the trial court, was not made available to this court. So my position is that it would be better left for him to work that out and do another motion to supplement the record if he gets that transcript sorted out with the trial court. And it's not an appropriate workaround to do judicial notice, to take judicial notice of Mr. Alston's separate post-conviction proceeding. All that being said, this is...
Did the post-conviction court rely upon it, at least implicitly?
I I'm not aware that it did. I didn't see anything in the record, at least in the post-conviction court's order, where it specifically cited that. I know Mr. Justice has pointed out, and again, I take him at his word, that he argued, made sort of closing argument in the post-conviction based on that testimony, and that even Mr. Allen was sort of in agreement that that testimony come in. So this is not a hill that we want to die on, because again, we're not afraid of Mr. Gindy's testimony. We don't think it's particularly important, especially on this point where the post-conviction court essentially accredited Mr. Allen's testimony. And on top of that, the fact that we think that Mr. Gindy's testimony is probably just hearsay, if anything. But we do think it's more appropriately addressed by way of a proper motion to supplement after he sorted this out with the trial court, to then bring that testimony up through a motion to supplement rather than through judicial notice.
So the state's position is this transcript is still in the trial court?
It may well be, Your Honor. It appears from the portions of the post-conviction transcript that Mr. Justice decided that there was an intent to actually introduce this as an exhibit, and that there was an attempt to do that. For whatever reason, the trial court just doesn't have it and has not made it available to the appellate court. So again, we're not particularly concerned with this issue. We're more or less happy for it to be made part of the record eventually. We just think that judicial notice is not really the appropriate workaround for this issue.
Your position is that it just should be supplemented if it's out there?
Correct, Your Honor. And I will say, General Orr asked me to request this, that if you do either take judicial notice or if the record is supplemented, it might be appropriate for us to get the opportunity to do supplemental briefing on that testimony, because she didn't have the benefit of actually seeing that testimony when preparing her brief. So to the extent the court's interested in it and does either supplement or allow judicial notice, I think she'd like to take a look at that testimony and have the opportunity to discuss it in a supplemental brief. So the other issue on these plea offer claims, these ineffective assistance claims regarding plea offers, this court and actually 2 of the 3 judges on this panel have already rejected the specific ineffective assistance claim concerning the all or nothing plea offer made and then immediately withdrawn in criminal court. So Judges Witt and Easter, you were both on the panel that recently decided this specific claim against co-defendant Webb, that's Webb versus State, that's number East 2022-220- 00243. And in Webb, this court found, based on the same consolidated post-conviction record that we have here, that the all or nothing offer in criminal court was essentially extended and withdrawn in the same conversation with Webb's attorney, Mr. Brown, such that Mr. Brown effectively had no opportunity to communicate that plea offer to Mr. Webb. And so this court reasoned that Mr. Webb could not show prejudice because he couldn't show that the state would not have withdrawn that offer. And the same rationale really applies here. The offer extended to Webb's counsel was withdrawn before petitioner's counsel even knew about it, and petitioner could not show prejudice because he can't show that the state would not have withdrawn that offer before it could have been communicated to Mr. Young or accepted by Mr. Young. And then lastly, I'll just briefly touch on this void for vagueness issue. This ineffective assistance counsel claim fails because this court has repeatedly rejected claims that our kidnapping statutes are void for vagueness. I did a quick Lexis search and immediately found 4 or 5 opinions where this court has repeatedly rejected void for vagueness challenges to our kidnapping statutes. And I think opposing counsel's counter argument to that is, well, there were different types of void for vagueness arguments made in those cases. It's not the specific one that he's making here, but I would counter that by pointing this court to Sterling versus State. That's number West 1999-00608. And it was a different argument that was being made in that case, but this court definitively held they rejected the contention that the statute is vague or ambiguous in any manner, and they said a reading of the statute is clear in all parts. So given this backdrop and this sort of ocean of authority where this court has repeatedly upheld the constitutionality of our kidnapping statutes, we'd submit that counsel was not ineffective for failing to raise this patently meritless void for vagueness challenge.
At the end of the day, though, we don't have trial counsel's testimony, right?
That's correct. I think Ms. Lemon or Lemons was not available for testimony at the trial court, and I don't recall specifically what appellate counsel's argument was for why he chose not to raise this issue. But I would make the same point that I made earlier, which is if we're talking about appellate counsel following the limited remand, would not have been an appropriate claim to make at that point because, again, he was limited to sentencing issues. So I think we only have to be talking about appellate counsel during the initial round of appeals. Maybe he could have made this argument. But again, I think trial counsel didn't make that argument at the trial court, so appellate counsel would have been limited to making a plain error, a waived plain error argument regarding this claim. So that's sort of another reason that appellate counsel, even during the initial round of appellate review, was not ineffective for raising this issue. So I'm happy to answer any other questions the court may have. Otherwise, for all these reasons, we respectfully ask that you affirm the judgments of the post-conviction court. Thank you.
We've heard a couple of different mentions
Mr.
about...
Justice, I failed to factor into your time the 5 minutes we have allotted to address the judicial notice issue. So if you want to further address that issue at this time, then you can do so.
On the judicial notice issue, I would just point out that the state asked for this testimony to be admitted. The state wanted this testimony admitted by Mr. Gindy. The judge wanted it admitted. I wanted it admitted. Co-defense or co-petitioner counsel wanted it admitted. Everyone wanted it admitted. And the judge specifically said, we don't even need to admit it. The court can take judicial notice of it, but he wants it admitted. He wanted it admitted just to have a clean record. So in those circumstances, I say the state is stopped from arguing that it's not admitted, and the court clearly can take judicial notice if the record shows I did admit it and it's just been lost.
But where is it now?
It's been lost. I mean, the clerk told me, as I said in one of my affidavits, that maybe it was lost, maybe it got lost in the judge's office. Who knows where it's been lost? But the point is, I clearly admitted in the record an exhibit on November, 2021, and the record doesn't show any exhibit having been admitted there in the court file, so somehow it's just gotten lost.
And you have checked in the trial court clerk's office, and it's not there.
I've checked by phone and had them check. I didn't specifically go look at it myself, but yeah, they've claimed that it wasn't there. And about, as for the issue of supplementing the record, I mean, I did file a motion to supplement the record, and then that's when the clerk said, well, we don't have it. And then, later the judicial notice motion came. So that's our position, is that if we don't have it, if this court already has it, this court should take judicial notice, as the trial court said that he was thinking about doing and would have done.
Do we have it?
It's part of the Larry Alston record. And I didn't get it directly from this court myself. I got it from the federal habeas court, but the federal habeas court got it from the opposing counsel's office, who got it from this court. So on the other issues, we've heard repeated mention about a supposed limited remand for sentencing. If we want to use that terminology, well, what happens after sentencing? Within 30 days of sentencing, you file a motion for new trial, and then you appeal. This is the first we've heard today about some kind of a procedural bar where appellate counsel was barred and did not have any right to appeal and did not have any right to contest the actual convictions of Young. And if that were the case, as I've said, then that would only mean that this issue is not waived because Young had no opportunity to raise it before. However, I've suggested he could have raised it before, because a limited remand for sentencing includes a right to a motion for new trial and a right to appeal, and that's what he should have done. He just didn't. He was objectively confused about what issues he could raise. The state has said that appellate counsel can't be deemed ineffective for not raising novel theories, but the problem is White wasn't a novel theory. White was decided about a month or so right after appellate counsel was appointed to the case. And in fact, he spent a whole appeal defending against the state's appeal, where they talked about a different part of White, a different White instruction, but he never did. But that same White case also talked about a substantial duration being required. That was never given to this jury, and he never challenged that as being a lacking, non-existent instruction. Opposing counsel has pointed to the pattern jury instruction and said that, well, the instruction I'm asking for is not much different from that. I agree, and the pattern jury instruction specifically cites White, and it specifically cites Young's case, State versus Alston, as being the specific example of when that instruction should be given. The problem is it wasn't given here.
But didn't the Supreme Court say, although it wasn't given, it was harmless error?
They said that about a different instruction, and I don't really dispute that, because what they said was there was no robbery here, so there's nothing to be incidental to a robbery. That's why in the pattern instruction it cites this case as a pure kidnapping case as the quintessential example of when you should give this pure kidnapping instruction, which is what I'm asking for. And so I'm not saying that the pattern instruction is defective, although I've suggested an improvement on it, but I'm saying we didn't get the pattern instruction or anything close to it. We got nothing. So the jury was not instructed. And I think I'm about out of time. I will just say Sterling has nothing, absolutely nothing to do with the vagueness challenge we've raised. It's talking about a completely different constitutional dispute. Ultimately, even if we were to just discount the plea offer, discount the de novo review on that issue, and just sort of defer to whatever the trial court said, regardless of whether it was based on the preponderance, ultimately, Young was convicted based on a vague, definitionless law, and he was convicted by a jury that wasn't even instructed on what scant definitions we do have for that law. And his trial counsel never raised any objection. He let it happen. By letting Young fall through the cracks in this way, for letting that unfair situation develop, trial and/or appellate counsel gave ineffective assistance, and we do ask that the judgment of the post-conviction court be reversed.
Thank you. The court is going to take a very short break at this time. We'll be back in about 5 minutes.